For joining us this morning. I'm DC Attorney General Brian Schwalb. With me is First Assistant Attorney General Lauren Haggerty and Liz Weiser, Deputy Attorney General for our Public Safety Division. Today I'm introducing legislation to address and improve how the juvenile justice system in Washington, D.C. operates at the critical time after a young person has been arrested and prosecuted. And in particular, what is being done at that critical time to make sure that these young people do not commit another offense. The legislation I'm proposing is specifically designed to improve public safety by reducing recidivism amongst juvenile offenders who have been prosecuted and convicted of committing the most serious violent offenses, youth who are in the deep end of the criminal justice system. I'll get into the details of this legislation shortly, but first I'd like to share with you a little bit about my perspective on public safety in our city at this time. Too many people in Washington, D.C., in all 8 wards of our city, don't feel safe. Residents are rightly demanding from their elected leaders and their government action. As the district's independent elected attorney general, there is no higher priority for me and my entire team than public safety. We are committed to using every tool we have to improve public safety for everyone who lives, works, and visits the District of Columbia. The Office of Attorney General is charged with prosecuting juvenile criminal cases and holding young people accountable when they break the law. The federally appointed U.S. attorney is responsible for prosecuting adult felonies. Adults, not juveniles, are responsible for the vast majority of crime in the district. But recently we've seen a disturbing trend. More and more young people are committing violent offenses, carjacking, robbery, gun crimes, homicides, and they're committing offenses at younger ages. And while it's a relatively small number of young people who are engaged in criminal behavior, that small group is causing a disproportionate amount of harm. I see firsthand the toll that violent crime takes on victims and their families. I see the far-reaching impact that violent crime has on neighborhoods and on communities and on our city as a whole. As the district's attorney general, there is no responsibility that I take with greater seriousness than my role as the chief prosecutor of juvenile crime. I undertake that responsibility with a clear, single-minded objective. We must do everything we can to make sure DC is as safe a place as it can be, now and in the long run. We charge every serious, violent crime when we have enough evidence to do so. We don't shy away from taking hard cases. We make sure that kids face consequences when they break the law, and that victims of crime get the justice they deserve. Since taking office last year, our prosecutors have been charging more cases at a higher rate, so much so that the capacity of our juvenile detention facilities at times has been stretched. It is imperative that a young person who breaks the law face swift and certain consequences. We know that swift and certain consequences result in greater deterrent impact than lengthy prison sentences. Those swift and certain consequences need to be meaningful and effective. They need to change behavior. Effective, smart, prompt intervention now will reduce crime and improve public safety in the short and long-term future. Policing and prosecution are critical parts of the criminal justice system. But there's another crucial part of the system that too often gets left out of the conversation. What happens after a young person who has committed a serious violent crime is arrested and prosecuted? What is the district doing to make sure that once that young person who has been prosecuted by my office is released, that they don't commit another offense? Juvenile justice systems across the country are different than adult criminal justice systems, and DC is no different. Juvenile justice systems recognize the need for both consequences and rehabilitative approach to ensure young people don't reoffend. In DC, for the most serious offenses, for the kids in the deep end of the criminal justice system, that critical responsibility of providing swift, meaningful consequences and rehabilitation lies with the Department of Youth Rehabilitation Services, DYRS. After MPD makes an arrest and our office successfully prosecutes the most serious of cases, youth are committed to the custody and care of DYRS. At that point, DYRS takes over. DYRS decides where a child is housed, in secure detention or under supervision in community. DYRS is charged with developing an individualized plan for each young person committed into its care and custody. In short, DYRS has sole responsibility for supervising and rehabilitating that young person to ensure they don't reoffend. Currently, DYRS undertakes that critical responsibility without enough transparency and accountability. The data and outcomes that we do have, however, demonstrate that DYRS is not delivering the results that district residents deserve. Since taking office last year, I have become increasingly concerned about whether DYRS is providing sufficient supervision and intervention to ensure that committed young people do not reoffend. I'm focused on data and outcomes. I'm focused on results. The most recent comprehensive data released by the Criminal Justice Coordinating Council indicates that 92.7% of kids who are committed to DYRS are subsequently rearrested. 92.7%. Almost every single one of the kids committed to DYRS care gets arrested again. That is not acceptable. Nearly 50% of the kids who are committed to DYRS are subsequently convicted of committing an additional offense. This is not acceptable. Whether recidivism for youth who have been committed to DYRS is measured by being arrested for a different offense or being convicted of a different offense, these recidivism rates are not acceptable. Reducing recidivism is an essential part of a comprehensive public safety strategy. We know, particularly with youth, that swift and certain consequences are critical in deterring crime, ensuring accountability, and changing behavior. DYRS's most recent performance plan for fiscal year 24, issued just in December, disclosed that less than half of committed youth, 45.3%, have a case plan in place within 90 days of commitment. 3 months to develop a treatment plan, much less implement one, is not acceptable. And for more than half of committed youth, DYRS's own performance plan indicates they don't even have a plan in place within the first 90 days. If swift and certain consequences are critical to deterring crime, to ensuring that youth take accountability for their conduct, to changing behavior, meaningful intervention needs to happen right away, not months down the road. The failure to ensure that all youth committed to DYRS receive prompt, meaningful rehabilitative intervention needs to be addressed immediately. Failing to do so not only abandons youth at a time when it is most critical and time sensitive, but it puts district residents' safety at risk. People who break the law, including youth, need to be held accountable. The prosecutors in my office are doing that every day, charging and prosecuting every serious case where there's sufficient evidence to prove that case beyond a reasonable doubt. But after OAG attorneys secure a conviction, we expect, in fact, we have a stake in DYRS effectively doing the work of ensuring that youth receive the prompt, effective services that accountability and rehabilitation require. That's why today I'm introducing the Recidivism Reduction, Oversight, and Accountability of DYRS Act, the ROAD Act. This legislation is designed to get DYRS on the right track. It lays out a roadmap for effectively and timely intervention and for effective and timely oversight and accountability, all with the shared objective of improving public safety outcomes. The ROAD Act does 3 things. First, it requires DYRS to promptly develop meaningful, individualized rehabilitation plans for every youth committed into its custody, and to ensure that those rehabilitation plans are implemented throughout the course of commitment. Second, it strengthens the court's authority to step in and intervene if it becomes clear that DYRS has not followed through on a committed youth's rehabilitation plan. And third, it provides for permanent, independent oversight of DYRS, so we can increase accountability and transparency. Again, I want to be clear, there's no doubt that effective policing and prosecution are essential, that consequences and accountability are needed when people break the law, and this includes young people. But the reality is that OAG prosecutors have involvement in kids' lives for a very short period of time. From the time a young person is arrested by MPD and charged by our office, cases are required to be resolved swiftly, often within 30 or 45 days. Compare that relatively short period of time with the extended periods of time youth interact on the front end with safeguards that are needed to prevent crime happening in the first place. Safeguards like family supports, schools, stable housing, access to health care and social services. And compare it to the extended amount of time youth interact at the back end of interventions. Interventions that are supposed to keep youth offenders from engaging in crime again. And in the most serious of those cases, that is an extended engagement with DYRS. I also want to be clear about this. The vast majority of young people in the District of Columbia are doing extraordinary things, often against extraordinary odds. The number of kids who are system involved, particularly those who have committed serious violent offenses, is small enough that this is a solvable problem. So often I talk with parents who tell me they've been begging for years, but their pleas for treatment, for counseling, for educational resources go unanswered. They ask me, why is it that their child needs to get arrested and prosecuted before getting the services and support needed to keep them out of trouble? The 14, 15, and 16-year-olds that my office prosecuted this past year, they were 4, 5, and 6 10 years ago. What happened across that decade? How many ways over that past decade has our city failed those children for them to end up where they are? Preventive efforts on both the back and front end of the system are needed to improve public safety outcomes. But especially when we have a child who has been committed to DYRS, we need to ensure that we do everything we can to ensure they won't commit another offense when their commitment is over. Otherwise, we're dooming them and the district to an unending cycle of crime. The proposed legislative changes in the Road Act will help ensure that DYRS delivers on its critical role in making DC a safer place for everyone to live, to work, and to visit. I look forward to working with the council to ensure that this necessary piece of public safety legislation is promptly enacted into law. So thank you for being here. I look forward to your questions.
Mr. Schwalb.
All right, folks, if you have questions, I'll call on you. Please state your name and your outlet. We'll do a round of everybody, and then if we have time for a second round, we'll do that as well. Go ahead.
Hi, Rebecca Turco with 7 News. Nice to meet you. If you can talk about why now for this legislation, and why was it so important for your office to put it through versus talking with the DC Council about it?
Well, I'm focused on outcomes and results and the data that we're seeing. There's no more important issue in our city right now than public safety. And there's no more important obligation for me as Attorney General to think about how do we make sure we keep our city safe when we're talking about juvenile crime. It is part of my responsibility as Attorney General not only to be the Chief Juvenile Justice Prosecutor, but to propose legislation when I think that a legislative fix is needed to make our city safer. And that's why we've introduced this proposed legislation today. And we will continue to work with the council to make sure that it's appropriately and promptly addressed and passed.
Do you have any stance on whether youth offender status should be lowered? Would that help?
I'm focused on making sure that when young people in our system now are arrested, that they get the services and support they need so that they don't reoffend, that we make ourselves safer by reducing recidivism. And we know that long prison sentences and punishment is not as effective as swift and certain consequences when youth are arrested and have committed an act of crime.
All right, additional questions, Raphael?
Yeah, Raphael with WJLA 9. Attorney General, is it safe to say, so you're saying that obviously without these plans in place for these juveniles, that's why you think that they're committing crimes again, and that's why you're addressing that they have to create this plan? Is that what I'm kind of getting to? Is that you're saying the majority of these kids don't have a plan in place by DYRS?
We know from DYRS's own report for last year, fiscal year 24, that the amount of time that it takes for kids who are committed to get a specific individualized rehabilitation plan is taking too long. And that period of languishing without a plan being immediately put into place has an adverse impact on kids being rehabilitated and avoiding recidivism. We're focused on trying to make sure that those individualized plans are put into place promptly, that they are followed up on, and that we maximize the chances that when kids are committed, they're getting the services and support they need to avoid having to perhaps come back into the criminal justice system when their commitment is over.
And just to follow up, is there a timeline in the point one that they have to require to create this plan? Is there like a you have to do it in a certain amount of time, 30 days, 60 days?
Our proposed legislation requires within 30 days of commitment that there be a plan in place. And that plan will be in place based on data and analysis and interviews and other information that the system has available to it to make sure that the plan is appropriately tailored for the young people.
Leonard Fleming, DC News Now. Good to see you again. Can you talk about the main point of failure from DYRS? Like, what aren't they doing that's delivering these results that you're talking about?
Well, this legislation is focused particularly on getting kids individualized rehabilitation plans as promptly as possible when they come into the system. From the moment of time when the system knows that a young person is going to be recommended for commitment into DYRS, we need to do a better job of making sure tailored plans are put in place for that young person, addressing that unique young person's needs to make sure that during the term of commitment, we can to reduce the chances that that young person's going to commit a crime again.
I mean, do you think it's staffing? Is it not enough employees, not enough people dealing with youth? What are some of the challenges?
Part of the reason why the bill also requires an independent oversight body is to make sure that we have better transparency and accountability into what is happening within DYRS so that we're in a better position to address that question and get to what some of the root causes within DYRS are for the types of outcomes, the unacceptable outcomes that we're seeing.
Stephanie.
Stephanie Ramirez with Fox 5. How are you doing, sir? I have multiple questions on this. DYRS does have oversight, and that is the council. So the fact that you're introducing this, what does that say about the mayor's office and department that handles DYRS and the council and their action so far?
I think that this legislation is designed to try to ensure that DYRS does a better job. Certainly with respect to oversight and accountability, that data will assist the council and the mayor in making sure DYRS is delivering for what district residents deserve. Being specific in the statute as to when and what rehabilitation plans are required to have in them will assist in making sure that the outcomes that we get from DYRS are better.
And then with regard to the mayor's buy-in or council's buy-in, have you discussed this with them yet? And then also, why not use the tools in place? One thing we had raised with your office is the ability to petition a judge to charge a 15-year-old as an adult, specifically the sweet and sour case. The parents, the family of the victim, were furious that that was not done when they said everything was in place with that case. I understand if you can't talk specifics, but can you speak to why not use some of the tools that you already have?
We're using all the tools that we do have available to us every day. One of the things that we're focused on, in addition to using the tools that we have, is focusing on this example of where the kids in the deep end of the criminal justice system are recidivating, whether we measure by rearrest or reconviction, at rates that are unacceptable.
Additional questions?
Ted Oberg from News 4. Good morning.
Good morning.
I wonder if there's any concern that we got to get DYRS to walk before they can run. The independent oversight agency that the mayor wants to close recently said that violence is on the rise inside the Youth Services Center. Arrests, we know from assault, positive drug tests. How concerned are you that the most serious violent youthful offenders are being victimized again in DYRS custody, regardless of whether they can make a plan to help them?
Yeah, the recent reporting about incidents at DYRS are very concerning. Unfortunately, they're not new, and we have to address that problem as well. I think additional transparency and accountability from the Oversight Board, which should be a permanent fixture of our government, will help us do that. But we have to do both. We have to also make sure that not only do we deal with violence and drugs and other things within facilities, but that when we do have kids in the deep end of the system in DYRS's custody, that we are making sure that we are maximizing the chances that they don't reoffend when they come out of the system.
Do you think current leadership at that agency can do this?
This is not about pointing fingers at the leadership or particular individuals. This is about making sure we have laws in place, a system in place, that regardless of who's leading this agency over whatever period of time in any administration, can make sure that we get kids what they need not to recidivate, that we get victims of crime what they need to make sure that they don't see kids recidivating, and that our community can have a greater level of confidence that kids who commit serious offenses when they come into the system are going to come out and not recidivate. That's how we make ourselves safer in the long run.
Questions? Yes.
Luke with WTOP, you mentioned specifically tailored plans to help these kids not recidivate. What exactly are you looking for in those plans? Can you give us some examples?
I think all plans are going to be dependent on the facts and circumstances of individual young people who are in the system. Part of it's going to be addressing what are their family circumstances, what's involved with their educational progress, perhaps educational learning. Many of the kids who come into the system have educational learning or have individual education plans. We also have to be mindful of some of the mental health and substance use addiction problems that children are facing that oftentimes are contributors to crime. We know that many of the young people who come into the criminal justice system are coming out of unstable housing. So all of these contributing factors in a particular individual youth's life need to be taken into consideration when a plan is designed to make sure that he or she, when they finish commitment, is maximally prepared to be successful and minimally likely to recommit a crime.
Alex at City Paper. Hey, so I wanted to ask a little bit about, the mechanism. I think anyone on the council will tell you pass a bill telling a city agency to do something. It only works if there's buy-in from the agency or, an enforcement mechanism in the bill. And you mentioned, maybe the court has a role in stepping in. So talk to me about how the legislation will actually enforce compliance from DYRS if they are resistant to it.
Sure. Well, my expectation is that DYRS will do its best to comply with the law, and the more clear the law is about timelines and expectations about rehabilitation plans, that DYRS will do what is required of it. I start with that premise. I think to the extent we have greater transparency and accountability from the independent oversight office, that enhances the ability of the public and of the council that speaks for the public to do its critical role of oversight, with the data and information necessary to use the oversight process to get agencies to perform better. The legislation also, though, allows for there to be a motion made to the Superior Court if DYRS is believed not to be doing what it needs to do in terms of creating a timely plan or implementing a plan, and doing it in quicker time fashion so that children are not languishing without a plan for too long. And so that mechanism is also part of this approach, and I think altogether, comprehensively, that's going to help DYRS rise to the occasion.
You also mentioned, how many kids who are committed to DYRS get rearrested. I have many people talking to me about how many kids who are on probation then go on to get rearrested, when they're under supervision from court social services. What is there, if anything, that you all can do to push more on the front end of this before kids are in DYRS custody?
Well, look, we're focused on addressing every case based on the specifics of the case that come to us. We do know that with respect to lower level offenses that don't involve guns, that don't involve violence, that the diversion cases that we divert to ACE diversion, which is less than 7% of the cases, have far greater positive outcomes in terms of recidivism, again, measured by arrest or by conviction. Same thing with young people who go through what's called a deferred disposition agreement, a plea agreement that allows them to get some services and attention right away, that their recidivism rates, both measured by arrest or conviction, are much greater. So we are mindful of that. We know that oftentimes when kids go into the deeper end of the system, we doom them for worse outcomes. That's why it's so important for us when we do have to put kids into the deep end, where we know that the seriousness of their offenses, the impact of their offenses require a more severe consequence, that we couple that consequence with making sure that they are getting the rehabilitation plan tailored to their unique needs to maximize the chances that they don't recidivate.
All right, we have time for two more. Ted.
As you introduced this legislation, the mayor just last month introduced legislation that would force your office to take fewer pleas, fewer diversions, and charge more kids. As you look at this issue, could more charges against young people be part of the solution?
Each case, Ted, needs to be addressed on the unique factors of the case. We judge them each time they come in based on the facts and make charging decisions based on the facts. I'm a little bit curious about why the mayor would propose putting more young people into the deeper end of the system, given her own CJCC's results of what happens and the recidivism rates that we're seeing from kids who are in the deeper end of the system, particularly given that the ACE diversion program, which is also administered by an agency that she's responsible for, is seeing such better outcomes. So we need to make sure that we have a comprehensive system that can address each kind of case based on the uniqueness of the case and try to drive to better outcomes. But we should be mindful that we are seeing better outcomes for young people staying out of the criminal justice system through the more shallow end of the pool than the deeper end.
All right, last question. Yes.
Rebecca again with 7. Going off of those reports of violence and drug use inside the juvenile detention centers, how is that affecting your office's decision making when it comes to requesting that suspects remain detained until their next hearing?
Our office is making a decision case by case on what we think is necessary to keep the public safe, to be an appropriate response for a young person who has been accused of committing a crime or has been convicted of committing a crime. We have to also address the fact that we need the facilities to be safe. We need to make sure that kids are held in custody in safe ways. But we have to do both. And that's why, in addition to doing the prosecutorial work we're doing every day, it's important for us to address this other issue about whether DYRS is delivering for young people who have been committed to it. And my hope is that this legislation is going to be a positive step forward to addressing that problem.
All right, that's all we have time for.
Thank
folks.
you all very, very much.
Thank you.
Thank you.